Council on record was also sent an email apparently on Saturday, that's what I'm informed.
What?
Even a copy of the papers, matter can be taken up any day,
We have not received a KV, but if your lordships directly, I will certainly serve. Some urgency, my lords, in the application we have filed, so your lordships may then kindly have it on Thursday or Friday.
Please, Thursday, my lord, I have no difficulty.
So and so has put in appearance
R1.
on for R1.
R2 to 4 may kindly be dispensed, my lord. They are the arbitrators.
The notice to R2 to 4 are dispensed for the time being. The copy of the appeal shall be served to the counsel for R1 during course of the day. Relist on
7th.
Thursday.
Yes, please. Great. Keep you.
Sir, 1 second. I may be disabled. I don't know.
Age 56 CDA agreement.
Just a minute.
I don't know, Nandakumar. Had I appeared? Had Dua appeared for this builder? Any idea?
Certainly not in this dispute.
No, definitely.
Not in this dispute at any stage.
But I'll verify. I'm sorry. I don't know. I'm off the cuff.
Just check. Please get it.
I'm sorry. I don't want to embarrass you. Sir, fine.
Right. All right.
Sorry.
Sorry.
56 is the order on section 9. Order granted is maintained status quo between developer and the builder, landowner.
Just a minute. Yeah.
When passing that order of maintaining status quo, for a moment, sir. This is where we see.
Just.
The order is not yet released.
Not yet released. Order is not yet released.
No, but not this one. This is another matter. This is a matter pertaining to arbitration proceedings, where between developer and landlord.
Low writ appeal.
Currently, about 4 acres of property was subject matter of joint development. Whereas we were ready to execute it, we are the developer. Then they said we have paid them about 12 crores. In the meantime, what happened? They raised certain disputes and sought interim measures, cancelled them. In the interim measure, we also filed a petition for interim measures seeking restraining interference and possession alienation. In the interim measure, court has rightly said both of you don't alienate, developer and landlord. It is on possession, it has said maintain status quo. But my lord, while passing an order of status quo against me, page 56 may be seen, running page 56, without a prayer from their side, the court has granted relief to them. Can you see the second from the top portion shall I read? The landowners, applicant and developer respond are directed to maintain status quo in respect of possession and enjoyment of scheduled property. Thereby, parties are restrained from doing any construction activity in the scheduled property. Till arbitration proceedings is disposed of by passing of interim order by the arbitrator tribunal. This is fine. We agree with this order. But the next portion says status quo.
Section 9. Who find?
We filed one petition. Landowner filed 2 petitions. They sought restraining alienation and restraining interference with possession. We also filed restraining alienation and restraining interference with possession. Court said on possession status quo. On restraining alienation, court injuncted both of us from alienating because there was a GPA permitting alienation. But in the last portion, the court says,
Page
56.
without a relief being claimed.
Just a minute.
Page 56.
Yes.
And the second para, status quo shall also mean to prevent the developer from using the scheduled property for space or as parking space for school houses. This is again free developer. Even this is fine for a moment. But kindly see the next order. Status quo shall not come in the way of landowners putting the scheduled property for temporary use. It is in conflict with the status quo. And this relief was not claimed by them at all.
Status quo, you are agreed by which or
They are agreed by this portion only.
third paragraph?
That is all.
Status quo order shall not come in the way of landowners putting the scheduled property for temporary use.
Yes, but page 68 is the relief sought by them in the interim measure. There they have not sought a relief for
How
temporary
you are
use.
agreed by this? How you are?
Our issue is that they have not specified, they have not even made a.
If it is temporarily put to use,
Yes,
how you are agreed?
but our grievance is that earlier we were using it for fairs and for parking purposes. Now they have injuncted us and prevented us from using it. But in the meantime, they have not sought a relief, number one. Second is, those temporary works, if it interferes with the joint development plan, which I have to obtain in the future.
Whether you have entered into arbitration or not?
That's
Now arbitrator is appointed.
arbitrator is appointed.
Is appointed.
Arbitrator is appointed.
And
Appointed means what? Whether you have entered into arbitration or
Give not yet.
Not yet.
Not yet.
slave petitions are appointed. In CMP, arbitrator is appointed. And in the relief sought, they have not sought relief for temporary works. The judge suddenly by himself he has granted. At least if I had an
doesn't make a difference. Doesn't make much difference. It is for that much discretion can be there with the court. That if they find it to be just and proper in the fitness of things, then they can enlarge the scope.
But at least there must be a plea on their part. At least there must be a plea on their part, saying that I want to undertake these temporary works. I should at least have an advance notice and a right to rebut it.
First, satisfy as to how you are agreed by this. If it is for temporarily use, property has been put to use.
The court has not defined what is the temporary use.
Temporarily means for the time being. For the time being, till this status quo is pending, till the application,
Under the JD, possession
arbitration proceedings are pending, till then only.
Under the JD, possession is granted to be for the purpose of development. It has been granted.
Let's ask them what is it that they want to do. Temporary use, why don't you define? You can define, right?
Yeah, we can define that.
Please tell us what is it you want to do?
That's we had put up a security.
No. Temporary use today.
Yes, my lords.
What is it you want to do?
For what purpose you want to use this?
But if my lords may permit me, Mr. Raghavan is appearing, my lords. Mr. Srinivas Raghavan is appearing. He's on his legs, my lords. Maybe passed over. If it's convenient to the court.
Sorry, not convenient.
That so far as the order is
It's
concerned,
not possible that after some arguments, then you say that some other person has to
at the
appear.
time I wanted to make that statement. Senior started arguing, so I didn't want to interrupt senior. He was presenting.
For what purpose you want to use this? Let us first understand.
That's to have accommodation purposes for our security guards who are residing there. As of
If you want to use it for parking of buses, etc., for the time being, then it can be treated to be a temporary use.
Yes, that's
But if you want to use it for some permanent purpose, then you cannot.
that's my
You will
clarification.
have to understand what is the use which you want to make.
That's the respondents, my lords, own a school. So only the school buses will be parked. Along with that, my lords, a temporary accommodation for our security guards will be put up.
No, sorry. No accommodation for security guard. We can permit the parking of the buses temporarily.
Pertaining to the respondents,
We will modify this to that extent.
may I make my one submission. With regard to the parking of buses, my lords, what has actually happened? My lords may look at one paragraph as to why the trial court has come to this conclusion. My lords. Paragraph 26, my lords, of the impugned order.
Yes. Come to paragraph.
My lords will get at 48.
Come to paragraph 26.
That's running page number 48, paragraph number 26.
Yes. Kindly read. What do you want to show from this?
That's the reason why they had sought for a specific relief saying that we should not interfere with their possession, my lords. That relief, my lords, was denied to them. On what ground and why they are also insisting that this word or this particular relief should not be granted to us can be seen by the observations made by the court, my lords. Paragraph 26.
To maintain status quo, so far as I'm concerned, I'm not insisting that I want to park.
Today, what has
That
happened?
order
my lords?
against me, I'm willing to suffer that order.
Results may submit two memos. What the respondent appellant is trying to do, my lords, is that he is trying to break open the wall from the behind and my lords enter and has parked buses today. My lords, I have the photos today and the police complaints which I have filed. My lords may allow me to pass it over.
Doesn't make difference.
My lords, they are trying to
What purpose
create
you
a
want
third
to
party.
use? For what purpose you want to use, that is.
That's we want to use it for parking of our buses, my lords. We
Okay.
run a school, my lords, by the name Holy Saint, and we would want to park our buses, my lords.
That you will clarify? That he doesn't have any objection if only for that purpose. We clarify this, that so far as this status quo order with regard to the observation made in paragraph 3 is concerned, that is only with respect to parking of the buses temporarily.
Of the respondent, my lords,
Of
the
the,
landowner.
Even my buses are there.
Are they,
so you also park, he will also.
That is all.
my lords,
That is all.
my lords, they're not, it is not their buses, my lords. They have the whole, if my lords, if that is taken into
How
consideration,
big is the property?
my lords, it's 5 acres, my lords.
And how many buses do you have? How many buses does he have?
My lords, he does not have any bus.
Then
No, both of
whosoever
them.
wants
No,
to
if they
make
want,
park it.
if they don't want
They
any,
don't have any buses, my lords.
We have buses.
They have leased it out, my lords.
see
They are-
see operative portion number 2.
Yes, sir.
Status quo shall also mean to prevent the developer, that is the appellant,
Yes, my lords.
from using the scheduled property for fares or parking space.
Yes, my
So
lords.
we'll say both of you park without interfering with each other's parking.
My lords, may make this submission. It is not their school buses, my lords. What is happening is that, my lords, next to this particular property, my lords, may look at this photos for a moment.
No, no, if he has violated that, that's not a ground for us to do. You will have to enforce it.
Please, my lords. My lords,
Right.
so far as the buses are concerned, they don't own any buses. I own a school. Today is a position where the landowner.
Why was this order passed with regard to parking?
Yes,
But
my
you
lords.
will not rent it out.
No, I'm not. Absolutely.
Right.
Not rent it out.
Our plea was that they are renting it out.
Because we'll clarify, they will not rent it out, both the parties can use it temporarily for parking of buses.
That's my only request is that, my lords,
If they have the buses, they can also park
my lords, it is
without
not-
interfering with each other.
my lords, may look at this.
We are not interfering, we are only clarifying the third paragraph of the order.
Second and third, both.
We will say that they will not rent it out and both the parties are permitted to park their buses temporarily.
Let me make one submission.
No permanent structure shall be raised there.
Let me make one submission, not for your lordship consideration. Let me-
Submission he has already made.
My lord, so, only one so far as what your lordship has proposed. My lord. If I may make one submission. My lord, parking of buses, my lord, is neither of the parties' intention, my lord, to use the property. May I make one submission, my lord? Even temporary use, not both parties will not make use for any purpose. My lord.
Yes.
Not neither for parking of buses, because what is happening, my lord, is the apprehension is, in the guise of parking of buses, my lord, a right is being created, my lord, to certain persons.
We will
We'll say
clarify.
that.
Therefore, neither party, my lord, will make use even for temporary.
We'll clarify and you enter into arbitration.
Absolutely, my lord. Therefore, since the arbitration, my lord,
There
is
you-
to be expedited.
Sec-
But
17.
even per temporary use, not neither party shall. Therefore, not neither party, not both parties will undertake. They will not use it even for temporary purposes. Right, and both parties will undertake.
Temporary,
Correct?
temporary purposes.
Let
What-
parking for
you
you.
also use it for parking, let him also use it for
But
parking.
that not is not, because there will be a clash on the ground. Right? It's going to lead.
There is no clash.
But on the ground, what has happened?
Then there is no clash.
But on the ground, what has happened is they have allowed certain buses to come in. I have not been prevented from even getting into the property. I put a barricade. They will not, neither party will not use it for, because that was not the purpose of the agreement. Agreement was not for to park buses. It was for development. I'm aware not they may be agreed.
Landowner, yeah.
They want
Developer, landowner is running a school, developer.
Purpose could use it. 5 acres of land is available.
There could be, on a recurring basis, there could be law and order problem, we don't know. So, both of you hands off till the arbitral proceedings come to an end.
But just remove all the buses, whatever are there. Neither party will do it, and both of us will undertake. Whoever succeeds, ultimately possession will be going to the. If we succeed in specific purpose of the DDA.
We were thinking in your interest that if you have the problem of parking of buses of a school, then you may
But by difficulty,
also have the
but influential,
we can restrain both of you.
he is more influential and powerful, that benefit will not be deprived to me. And he will create third party interest, right now.
We'll say that. See, third party interest, claiming equity, without all that we'll
Nothing
protect.
that
My submission, I would be willing to not even take a damage that even temporary use I cannot put it. Not anyhow, the arbitration is because within 1 year. He has already suffered for 3 years. But I would say that let us not.
Equitable use for parking for both of us.
That's why we asked how big is the place. Can you demarcate? Everything is vacant, right? As on today.
It is vacant, but right now, after the order, he has come with a JCB, erected a barricade so that I cannot enter the property.
We'll take note of that. We'll take note of that, and we'll also say only for the purpose of parking.
Parking alone.
One portion let them park, one portion you park.
But we are willing to forego, let it not be for any purpose, because our apprehension is.
extend kar do.
All right. No, see, that's what that recurring. See, again, you should not come back to this.
That's the difficulty. On the ground, already counter police complaints have come, police have got involved.
We will restrain both of you.
Please.
Right.
Dispose of.
Right. This appeal, one appeal is it?
Possession, so far as possession status.
We won't say anything. We won't say. We only modify that order to the extent of saying both of you don't do any temporary activity there, including parking of buses.
Please.
Right. Only one appeal, is it?
Please.
One.
Right. This appeal is directed against the impugned common order dated 2nd March 2022, passed in Commercial A number 142 of 21 and Commercial A number 179 of 21 and Commercial A number 42 of 22 by the learned LXXXIII Additional City Civil Judge Bangalore, whereby the said applications filed by both the appellants as well as the respondents were disposed of by the trial court, a commercial court. Next para. Heard learned senior counsel for the appellant and learned senior counsel for the respondent and peruse the material on record. Next para. A perusal of the material on record indicates that the appellants are builders who were respondents in Commercial A number 142 of 21 filed by the respondents herein under Section 9 of the Arbitration and Conciliation Act 1996 for injunction restraining the appellant herein from alienating or creating encumbrance or raising loans or carrying on business with dealing or in any manner transacting in the scheduled property. Full stop. The respondent also filed Commercial A number 42 of 2022, also under Section 9 of the said Act of 1996 for injunction restraining the appellant from interfering with the respondent's possession and enjoyment of the scheduled property. Full stop. So also the appellant herein filed Commercial A number 179 of 2021, 179 of 2021 for to restrain the respondents herein from interfering with the appellant's possession and enjoyment of the scheduled property and to restrain them from alienating or creating any encumbrance or third party rights in the scheduled property or dealing or transacting with the scheduled property with any third party. Full stop. All the three applications having been contested by both sides, the commercial court proceeded to pass a common order in the following terms. Page 55, kindly extract. Next para. 55, 56. 55 and 56. Full stop. it is the grievance of the appellant that the grievance of the appellant in the present appeal is restricted to the following portion of the impugned order. Extract.
Status quo.
Status quo order shall also mean to prevent the developer bracket appellant close bracket from using the scheduled property for fares or as parking space for school buses. Next para, status quo order shall not come in the way of the landowners putting the scheduled property for temporary use, close inverted commas. Full stop. Per contra, learned senior counsel for the appellant submits that despite the impugned order restraining the appellant developer from using the scheduled property for fares or as parking space for school buses, subsequent to the impugned order, the appellant is trying to change and alter the nature and character of the scheduled property and is attempting to violate the impugned order passed by the commercial court. Next para. The said contention urged on behalf of the respondents is vehemently opposed by the appellant who disputes the said contention. Full stop. In view of the full stop, learned counsel for the senior counsel for the parties. Learned senior counsel for the appellant points out that the impugned order, insofar as it relates to permitting the respondents, landowners, putting the scheduled property for temporary use, would result in the respondents changing and altering the nature and character of the property and parking buses, vehicles, etc. in the scheduled property. Full stop. The next para. What do you want to say? Right. Any other submission? That's all, no? Yes. That's all the submission, right? Learned senior counsel for both sides submit that the arbitration, learned sole arbitrator, is it? Yes. Sole arbitrator having already been appointed and entered and has entered reference, and the matter is posted. Is there a date given? No,
Has been appointed only.
Has been appointed and has entered upon reference between the parties. Full stop. In view of the aforesaid facts and circumstances and the fact that the arbitrator has already entered upon reference for the purpose of resolving / adjudicating the dispute between the parties, without expressing any opinion on the merit / demerits of the rival contentions urged in the present appeal as well as in the claims before the commercial court as well as before the arbitral tribunal, we deem it just and proper to dispose of this appeal by modifying the impugned order passed by the commercial court by directing both parties not to use the scheduled property for any temporary purpose, including parking of buses, vehicles, etc., till disposal of the proceedings by the arbitral tribunal. Full stop. All rival contentions are kept open and no opinion is expressed on the merits / demerits of the rival contentions, and the arbitral tribunal is requested to dispose of the proceedings without being influenced by the observations and findings recorded in the impugned order, right, or by this order, right. Full stop.
Or by the good
In the impugned order.
Apologies.
Right.
pleasure.
Charging this to an order under section 34, passed under petition under 34. Appellant before your lordship to the claimants in the arbitration relates to the construction of a section of the Metro Millard project. I had preferred around 16 or 17 distinct claims, out of which around 10 were granted by the arbitral tribunal, which comprised of technical arbitrators, because it related to construction. A very detailed award has been passed, 311-page award. The respondent had also lodged counterclaims, they were rejected. But the 34, which is preferred by the respondent, the learned judge says, the commercial court says, that yes, the arbitrators have gone into all the details, they have referred to all the documents, they have applied their mind, all of these remarks are made. But on one aspect, insofar as what is termed as finance charges, he, my lord, reverses the award. And that reversal
has the effect of setting us virtually taking away about 40 crores which I have had the benefit in the award. That is why I am before your lordships in an appeal. The original award,
Let notice.
Let note.
Issue notice.
please.
To respondent number 1. Notice to respondents 2 to 4 dispensed with.
Lordship.
List after service of notice.
May I make one request? There's also an application that I've preferred for extension of the bank guarantee. I can't press for an ex parte order. May I also be permitted to serve the counsel who is appearing in the commercial court in a relatively short date?
I don't know, Metro, they may have a different counsel for the trial court, for the commercial court.
Please, my lord, in addition to court, sir. In addition,
there too, permission is granted.
You take hand notice only.
please, I'm ready.
Instead of serving the council,
I'm ready.
serve them. That is a corporation.
That's it.
In that case, could it be
In
the week
addition to
start?
the regular mode, the counsel for the appellant is permitted to take hand notice to respondent number 1.
Please, 22nd or 23rd if a date is fixed, my lord. Great.
24th.
Great.
Respondent number 3, my lord. I'm appearing for respondent number 3, BBMP membership.
So appears for respondent number 2. That is why we are asking.
My lord, I have filed a memo of retirement on behalf of respondent number 2, and another counsel has already represented. Kindly delete my name, my lords. H.M. Murlidhar.
He has filed a memo of retirement and he wants to retire from the case. So Mr. Muralidhar is filed. R2. Mr. B. Sridhar?
Has entered appearance on behalf of R2.
Name is Sridhar. Objection has not been removed.
The societies. Karnataka Government Class D Employees House Building Cooperative Society.
Also is not sure.
Sridhar and their society. Yeah.
Sridhar has filed. The prayer in the writ petition, my lords, is relating to civic amenity sites by the society. Now, my lords, under section 70 also they can raise the dispute before the cooperative society authority.
PIL alive. Member alive.
Members.
Member 70 baral.
BBMP, if sites are available, BBMP has to take fence those sites.
Who is this petitioner, Sai Datta, and why is he interested in this? Then why this?
PIL.
PIL, correct, but society allotment to this person. No, nothing is said with regard to his locus, that's why.
What happens is when the objection, all those are reported,
Right.
the court gives time to remove the objection and the main question of maintainability is goes in sideline.
Yes.
Same is your case.
No, at least you have the first paragraph you have said, you have filed several public interest litigations. At least to show a bona fide, you can mention which are those.
So, yeah, how it is maintainable
I know.
for the relief claim.
Some basic locus has to be there, no?
What is your grievance?
That not been handed over to the BBMP. BBMP has to maintain civil community site. It's for the other public interest. That's a large space for the.
How it is public interest? Who are you?
I'm not concerned with the.
But you are not You are not concerned with the layout. You are not resident of the society.
No, I am not a resident of this.
So you cannot be said to be agreed in any manner.
I am not personally agreed in any manner.
Yes.
I am not personally agreed. Because the lordship can the civic community side.
But interested in taking property in that society.
No, I am not interested in, I am not even interested in taking the property at that side. I am not interested in taking any property in Bangalore.
Then what is your interest?
My grievance is that the layouts are farm, civic community are kept. But without giving it to the BPMP, handing over it to the BPMP, because the last kind is immediately it is kept, it is left with the government. Government has to take under section 174.
Society is undertaking the work on the sanctioned plan. On the sanctioned plan or on the sanctioned plan? This is your case. But they are not handing over the sites for the basic amenities to be developed by BBMP. This is your grievance only. Go and make a complaint to BBMP. Let them see their responsibility.
For this civil suit is also pending. The society has filed objection saying that these civic sites are sold by somebody by creating false sale deeds on the basis of a fraudulent document. Civil suit is pending.
They said they have requested the BPMP to take over.
Ramesh Chandra, if there is a civil suit pending, and if there are if there are disputed questions of fact, that in a PIL, what
have you mentioned? Have you mentioned this thing that civil suit is pending?
He has not mentioned.
Then
Society has mentioned.
I don't know because now society has come up with this contention saying that.
what is this? Give the detail of the civil
There
suit.
is OS number.
1558 of 16.
Yes.
1558.
Relating to very same sites.
2016.
Filed by society against
Ram Singh Uday Kumar.
against
Not to implicate, not to tell the layout. They are not.
so there is a rival title dispute in relation to the society itself.
There is no rival dispute.
Look at page 134 prayer. Declare that the sale deed so and so.
Take down. Heard. This public interest litigation has been filed, seeking following relief. The grievance of the petitioner is regarding the alleged non-handing over of the site for development of basic amenities to BBMP. The petitioner, being a public spirited person, wants proper development of the site of the society. Respondent number 3. First of learned AGA, preparing for first respondent, points out that the civil suit with regard to title dispute of the land in question filed by
Society.
second respondent, that is suit number 1558 of 2016, is pending before the court of
Principal Senior Civil Judge, Bangalore Rural District, Bangalore.
This fact has not been disputed by the petitioner counsel. In view of above, we do not find any ground for interference at this stage, particularly when the land in question itself is disputed and in any way it is not a fit case for grant of intelligence. First of the The petition is accordingly dismissed.
They are ready to hand over.
But they are ready.
Pleading application is pending.
All applications dismissed. Yes.
Lord, I am appearing for the petition in this matter. Lord, the prayer sought for by the petition has become infructuous. Therefore, I have filed this memo for seeking permission to withdraw the present petition, Lord.
This petition has been filed seeking following relief. Counsel for the petitioner indicates that he has filed a memo for informing that the petition has become infructuous and it may be dismissed as not pressed. The writ petition is accordingly dismissed.
Much obliged.
Matter pertaining to that loan
Surface.
happened in that area.
ಬಂದಿಲ್ವಾ?
Yes, service the loan to an extent of about
चाहे वहां से बोलो ना उनको.
ಸಾಹೇಬ್ರು, ಪಂಡಿತ್ ಸಾಹೇಬ್ರ.
service the loan to an extent of about 1 crore.
Why didn't you contacted the office of that court to get that order uploaded at least?
It was, this happened on Friday, we complied with all the objections except this. This we could not get. It is a lady, she's an advocate. That is the, and today the police are moving,
Observation करना
take
चाहिए.
possession.
It doesn't look proper. We'll have it tomorrow.
One difficulty is the police are making efforts to go to the magistrate court, take the warrant. And bank
Get the
officials-
order uploaded.
At least till tomorrow.
Ask the staff to upload the order today. We'll have it tomorrow. We'll have it tomorrow.
We'll get it uploaded.
The protection lot till tomorrow.
We don't want to make any observation on that. Unless the order is before us, we cannot.
Issue is that they will, now they are already.
No, if we make any observation, that is not good for the institution. Therefore, we are restraining.
Let them not precipitate it tomorrow.
Don't
As I see, and our children are residing in the property.
tomorrow there is no order. How can anybody can proceed?
Proceeding very rapidly to take possession.
Let's see it tomorrow.
Well,
Yeah, for the petition of Lord. Petition of Lord under section 37 of the Arbitration Act. Petition under section 37 of the Arbitration Act, my Lord. Lord, in fact, notice is issued in this matter and the department is already served.
Seek a short accommodation in this matter, my lords.
For what?
My lords, it's an award for 166 crores, my lords, has been passed, my lords. And state has also preferred a petition under section 34, my lords. That was also dismissed, my lords. And some instructions I required, my lords, a week's accommodation, my lords.
When it was filed, have you been served?
In this, yes, my lords, notice has been ordered by this honorable court.
Then, what are your instructions? What are your instructions?
I'm yet to have written to them, my lords. I'm yet to get the entire documents and that's all.
We'll see whether anything wrong in the order.
Yes, yes.
Huh?
Yes.
Or on your request, shall we adjourn it?
No, my humble submission is that for me to make any submission before this honorable court, yes, my lordship.
Your chance will come afterwards. Your chance will come afterwards only when he satisfies the court.
Yes, yes.
First, let him have
Lord, if I may
chance
make
to
one request.
satisfy the court at least what is wrong in the order.
Please, I'm ready to go ahead, my lord, but only one submission, my lord, is that if the state is to file a cross objection, my lord, both matters can be taken up together.
Cross?
It is fixed after 10 days.
Yeah, in appeal. We are in the appeal in 37.
Please.
Were there any chance of cross objections? If they want to challenge it, they can challenge it on their own.
Please, I will go.
There is no question of any cross objection.
No, did you file a section 34 against the arbitral award?
Yes, we did
It
file.
was dismissed.
Where is that? We don't, do we have, is it part
No,
of,
Lord,
It
that
is
is
not,
not.
their separate orders are passed, Lords. That is,
against that have you filed a section 37?
no, as of now, we have not.
That is fine. So there's no question of
No
objection. Na? That is what I am saying. There's no question of any cross objection now.
You only have to decide this, that's all.
That is all. Yes, Mr. What is wrong in the order?
Lord, in fact, in the matter, Lord, senior advocate is engaged. I will only request, Lord, that a date be fixed in a week's time, Lord.
We don't give chance to senior advocates to argue. We give chance to young lawyers only.
Please. Lord, Lord, I understand, Lord, that in an application under section.
It is to be finally decided. It is to be finally decided.
Please.
Mr. You take complete instruction in the matter. No further chance. No adjournment.
Yes,
If I may request, Lord, that a date may be fixed in the matter because the dispute starts in 2012.
Because whatever you have to do, if you have to challenge it, you challenge it. We cannot keep the matters pending for nothing. Otherwise, what we prima facie find from the order is, it is absolutely perfect. There is nothing
as far as this
to interfere by us
appeal, my lords, we
in
have to
37.
oppose that there is a separate order passed. That
There is
challenge
hardly
is
anything.
different.
We cannot decide the merit
That
of the award on what scores the arbitrator had decided. That is final. Not an appeal that we will enhance or reduce. So, on the request of counsel for the UFPF respondent, the case is adjourned today. However, with the understanding that on the next date, the case would be finally heard and disposed of. List. Give a short date next week.
Please.
Next week. Give a date.
I appear for the appellant in the serial number 8, my lord. In serial number 8, my lord, I appear for the appellant.
Yes.
My lord, what is challenged, my lord, is the award of the learned arbitrator. My lord, where the learned arbitrator, my lord, by his award dated 19th January 2021, my lord, in relation to an agreement for joint development, my lord, superimposes a condition which is not there in the joint development agreement to the effect that my lord, the owner can seek eviction of the developer from the property. My lord, there was some delay in, my lord, putting up construction and developing the property. That is how disputes arose. My request, my lords, to kindly take, my lord, page number 67.
Your 34 was dismissed.
34 has been dismissed, yes, please, my lord.
You are
My lord,
the
award is in my favor, my lord, except to a smaller extent, where they say, my lord, that the landowner will be entitled to evict me only to the
You are respondent in the arbitration proceedings.
Appellant.
Appellant. Claimant.
Yes, I am the appellant. I was the claimant, my lord, and before 34, my lord, I was the petitioner. My lord, page number 67. I am agreed only by a small, my lord, portion of the order. If page number 67, my lords, were to kindly see para 20, In view of the reasons aforesaid, my lord, para 20 in page number 67,
Yes.
and in the interest of both the parties, it is appropriate to extend the time to the claimant to complete the construction within 12 months from the date of this order, and put the owners of the land to their share in all the stairs of the apartments, and thereafter he is at liberty to sell the remaining apartment to the purchasers. My lord, this is in my favor. In case the claimant fails to comply with the directions mentioned above, it is open for the respondents to seek eviction of the claimant from the premises.
क्या ये owner है कि developer है?
Developer.
You are owner or developer?
Developers.
But I am the developer, my lord.
Huh.
So therefore, my lord, on account of, my lord, COVID, there has been some delay in, my lord, completing the construction. But, my lord, the condition superimposed by the learned arbitrator, my lord, that I will be evicted from the property is something which is not there even in the original joint development agreement. Nor is it their claim of the owners that, my lord, I should be evicted from the property. My lord, to this limited extent, my lord, I had gone in to the commercial court, my lord, under 34. Only to this limited extent, my lord. Otherwise, rest of the award is in my favor, my lord.
Why can't he extend the time?
Term of the contract. Right to seek eviction is not a term of the contract.
No, it is not a term of the contract. It is something that is super added, my lord, and in my respectful submission, the arbitrator cannot make a contract for the parties.
The only issue notice.
That's all. Emerger notice to 1 and 2, returnable by date code. Notice to R3 dispensed with.
If we want.
Yes, please, my lord.
Notice.
Appellant also permitted to take out hand summons to respondents 1 and 2.
But some interim relief, my lord, where they will not interfere with my.
Have a
my
short
lord.
date.
Yes, my lord, very well.
Have a short date.
28-3.
My lord, date, my lord.
28.
28-3.
I'm grateful. I'm grateful.
Number 9. For the exceptional year, appellant in this case, Lord. But earlier occasion, Lord, the honorable court directed me to take out the hand summons, Lord. I have collected the hand summons, Lord. But I am told that, Lord, the respondents are not residing in the same address, Lord. Therefore, Lord, I may have to seek some more time, Lord.
You will have to take fresh steps then.
Please, Lord,
What
I
is
will
the
take
service? What is the office note regarding service?
Non-forgiving.
On 11-2, my lord, it is not been served.
Oh, what about the regular mode? Only hand.
I may permitted to take out the notice to the council also, Lord, in addition to the.
No, sorry. If you are not aware about the respondent, then we can't do anything. Will you take fresh steps?
Lord, I will take the steps, Lord. I will take note today.
Then the counsel for the appellant informs that respondent is not residing at the given address. As such, respondent number 1, both 1 and 2, both.
1 and 2, Lord. They are the husband and wife, Lord.
Respondent 1 and 2 are not residing at the given address. Hence, hand notice could not be served. The counsel for the appellant undertakes to provide the new and fresh address of the respondents and take fresh steps for service after the fresh address along with the EF giving the correct address of first respondent and second shall be given within 1 week. Office shall proceed thereafter. In addition to the regular mode, the office may issue hand notice to counsel for the appellant for service on respondent number 1 and 2.
Number 10.
For the appellant. This is a challenge the order passed by Annexure H.
Garam क्यों लग रहा है ये fan?
AS 75. Annexure H is the order which is a challenge before this honorable court. Annexure H is the order passed by the 4th Additional Civil Judge Bangalore dated on 19/1/2022. The finding of the court is, since I have said in the section 34 of the civil code, notice has not been served. The court has come to conclusion, notice has been served that
Maintainable.
not appeared, therefore, the appeal filed by me is dismissed. Here, appellant has borrowed some more rupees 25 lakhs from the respondent to pay in 24 installment. I have paid more than rupees 14 lakhs and I was due only 8 lakhs. Even before the lower court, I had deposited about 4 lakhs 29,000 rupees 791. The dispute is only they demand 17 lakhs, whereas the appellant liable to pay only 8 lakhs. My humble submission is only to remand for a limited extent to dispose of the matter within 3 months or 6 months. I am going to prove that I have paid the money. Even pending the arbitration case, we have collected the DD and the bank amount. My grievance is I am liable only 859. Out of that, I have paid rupees 359 before the lower court, 50%, 4,29,791.
Issue notice.
Notice.
Emergent notice returnable by date ಕೊಡಿ.
Execution ಆಗಿದ್ದಾರೆ, they move for the execution number 4294 of 2018.
But in stay application ಇಲ್ಲ. 28-3.
Jurisdiction. So on that we can dispose. Both the parties. You serve the other side, dispose it off on the next day.
But they have filed already execution, which is posted on 34.
Nothing will happen in 1 day. You serve them, you take hand notice if you want.
Hand summons, in addition there to hand summons.
Number 11. Raji Kolle.
Then on the product sought by the counsel for the petition.
Number 16 also.
6th June. Number 12.
Same.
And serial number 16 also. Serial
Just
number
wait.
16 they are not.
Wait for your turn. Wait for your turn. Are you in a hurry going somewhere? Just wait.
Number 13.
13, I appear for petitioner, my lords, in this case. Last occasion, government advocate requested to file a status report of inquiry.
Lord, during the course of the day, it will be 5 minutes. Some technical issues. Proceedings are initiated. The status report will be filed during the course of the day. My apologies.
Is regarding preservation of government land in Bangalore.
A status report would be filed during course of the day. On his request, case is urgent. Give a short date.
Request for next week, no? For the petition, no, request for next week, no?
Respondent number 6.
Who appear for the petitioner?
For the petition, my lord, I given NOC, my lord. The NOC on record, my lord. You see, 1 week time, my lord. Take up next week, my lord.
He has given the papers back to somebody else, but he is not coming.
What can be done? We dismiss it?
No, take him next week, my lord.
Pass it over, we'll take up again.
Number 15.
Mr. Mahendra, you see the file. We'll take up again.
What is SIP stay? Direction must to be complied by the state. Framing of the rules of the GJ Act. On section 35 we are required to frame the rules by the state government. Subcommittees and committees are submitted a report to the state. They are examining directly present here. Because another 4 weeks time is required for us so that we publish the draft rules. Under section 35 surrender of the child is subject matter of present petition. Prayer has been complied, child has been taken. It is given.
Who is examining what?
Plus, subcommittees have been constituted for the purpose of drafting the rules.
The position earlier also.
Yes, ma'am. Now that they have submitted the report, committee has submitted the report. Director of Women and Child Mellors and the Principal Secretary of Women and Child Mellors, they are considering that. Once they vet that, then they will send to the cabinet. For that reason, some input from the law department is also required because it is a rule. The bureaucrats, they will not be able to have a expertise. For that reason, they are consulting the law department also. For that reason, some more time is required. Because it's amendment of the state, we don't have any rules under the GJ Act. We have adopted the model rules. In respect of section 35, direction is there to frame the rules. That some time is taking. That is the reason I'm saying.
It has not yet been placed before the cabinet.
Once it was placed, that cabinet could not approve it. It has sent back. Again, committee is constituted. Committee has examined. Committee has submitted the reports now. Now that committee's proposals are being considered.
We will have to then call for appearance of some.
Director he has come today to brief me. He is here. To morning he has come. I informed that he will complete the. Some time he is asking so that he will go and brief the secretary, apprise the proceedings, and then immediately speed up the.
Oh, how much time you will take?
Framing the rules. Different departments, law department consultation also is required. That is the reason it is taking.
Law department is not cooperating.
No, they are cooperating. It's not that they are not yet gone to them. So we cannot play. It is required. These are the processes. I am just explaining.
Cannot keep the matter indefinitely. For
yes.
What? For your amendment in the rules.
Yes. Rules they are now draft rules.
Earlier you framed certain rules. Thereafter, the amendment in the Juvenile Justice Care and Protection Act came. Therefore, you said that could not be approved. Now, thereafter, you are continuously seeking time, doing nothing.
The last chance, may show kind indulgence, will come back. She is there, presently. For that reason only I have asked her to be present. I have seen the order sheets. On 3 occasions, we have sought adjournment on this. Implementation of anything, so we can immediately, but for framing rules, some this thing is required. For that reason, I am seeking small indulgence.
Last time you said 4 weeks, we granted you
yes,
4 weeks.
Yes, it is granted. It is granted.
Still same position? No, we don't permit this.
Yes, we know, for that reason. Responsible officer is here, so we will apprise the secretary also.
What can be done?
Let me show last indulgence, thereafter, if it is not there, may kindly observe that, if it is not done, let the secretary be present, so that immediately, so will be.
When the AG correspondent informs that the second respondent is, that is director, Department of Women and Children is present. She has sought a short accommodation. Enable her to apprise the Principal Secretary,
Please.
Department of Women and Children, regarding the new rules
Please.
and seek approval. Considering the request as a last opportunity, we provide respondent time to place the amended rules, bracket with new rules, before the court. Give a date after 4 weeks. Request for short accommodation made by the petitioner.
The other side to furnish the copy.
Give copy to him. Give one more copy to him. Adrian.
Number 17. May I please, Lordship? Because I appear for the petition, Lords. On the last occasion, Lords, the respondents had taken time to file their statement of objections to the writ petition, Lords.
I request my lords, I will grant me a week's time. I receive the instructions, my lord. I file my objections during the week, my lord. Week's time I kindly be granted.
Appear for?
I appear for respondent number 1 and 2, my lords.
The counsel appearing for respondent number 1 and 2 informs that he has received instructions. He will file the statement of objection within 2 weeks.
Please, my lords.
Who appear for third and fourth?
I appear for respond number 1 and respond number 4, my lord.
1, he is saying 1 and 2?
2 and 3, BDA, 2 and 3.
My lord, it is KSMCL is R1 and R2 is
Say 2 and
KSMCL.
3. Well, not 1 and 2, 2 and 3. Yes.
I am
You appear for 1 and 4.
1 and 4. Karnataka, State of Karnataka and Deputy Commissioner.
I am appearing for 2, my lord.
I am sorry, my lord. I am sorry.
Only 2, not 2 and 3, huh? Only 2. You also file a statement of objection.
File objection. Virus is challenged, you know.
Is Leonard AG appearing for 1 and 4?
Yes.
As well as counsel for respondent number 3 may also file their statement of who appear for 5 and 6?
I appear for respondent number 5, my lord.
Eh?
I am appearing for 2, my
I appear for
lord.
respondent number 5.
Five and 6 may also file their statement of objection within 2 weeks.
Grateful.
18.
I appear for the petitioner.
Yes.
For your lordship, challenging the order of the learned single judge, whereby my request for consideration of my representation came to be rejected. The matter lies in a very short compass. The land laws originally stood converted. Thereafter, without taking note
Action
of
taken by state subsequent to decision taken on the Karnataka Appellate Tribunal. What is the matter?
let's briefly, the land
originally stood converted from agricultural to non-agricultural. Without taking note of it in the year 97, the land was reclaimed back to the government. That was challenged before the appellate tribunal. Appellate tribunal quashed the order, remanded back. Once again, the land was reclaimed. That was once again challenged, then the appellate tribunal held in my favor that the land does not belong to the government. It belongs to private parties. Despite the quashing of the order, reclaiming the land, the name of the government continues in the revenue record. Therefore, I made a request that the order reclaiming the land itself is quashed. Therefore, kindly delete those names from the revenue record. That representation is not considered.
Yes, what do you say?
Lord, sir.
That is in fact correction of revenue record.
That's all.
There is a procedure for that or not?
That procedure is undertaken. The order reclaiming the land back to the government was quashed by the tribunal twice. Therefore, what remains is only a formal clerical mechanical deletion of the entity.
Yes, my lords, I have sought for instructions, my lords. Anytime they would be giving it. It may be posted tomorrow, my lords. I will get back on that.
No, you consider the representation. We'll set aside the learned single judge's order.
Yes.
You consider the representation bearing in mind the tribunal's order and
yes.
in 3 months.
That's all.
That's all.
Yes.
Single judge order nahi hai koi. It is writ a petition. Writ petition. Writ appeal.
It's 29th. 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 31. Correct. Sorry, sir. This competent authority, the wrong finding of fact. Appeal number? The second one.
It is 1146 of 2013 and 880 of 2013.
Whether that order of KIT has attained finality, you have not challenged it.
No, we have not.
It has attained finality.
Yes.
You are duty bound to comply it.
Yes.
You are not doing anything. That is why he has to come again.
So, my lords, sir.
Anna, that is the only
That's
thing.
all.
Or the London single judge have dismissed the petition.
Correct.
Consider his representation in the light of the order passed by the
Okay.
Yes.
KIT. Will dispose of.
Right.
Appeal.
This appeal by the writ petitioner in WP 908 of 21 is directed against the impugned order dated 25/1/2021 passed by the learned single judge, whereby the said petition filed by the appellant seeking a direction to the respondent state to remove the name of the government in the revenue records pertaining to the subject land by considering the appellant's representation at Annexure B dated 23/9/2020 was dismissed by the learned single judge. Heard learned counsel for the appellant and learned AGA for the respondents and perused the material on record. A perusal of the material on record will indicate that that the Karnataka Appellate Tribunal Bangalore, in appeal number 1146 of 13, clubbed with appeal number 880 of 2012, dated 23/8/2019, produced as Annexure A to the writ petition, has upheld the claim of the appellant with regard to the subject land and has directed setting aside of the order dated 14/2/2013, isn't it? And 8/8/2012, passed by the Deputy Commissioner, Bangalore District. Full stop. It is the grievance of the appellant that despite the aforesaid order passed by the KAT, Karnataka by the tribunal, and the appellant submitting a representation dated 23/9/2020 to the respondents for requesting them to comply with and give effect to the said order passed by the tribunal, since the respondents did not take any steps / pass any orders on the same, petitioners preferred the aforesaid writ petition before the learned single judge. Full stop. It is submitted that despite the aforesaid order passed by the tribunal having attained finality and become conclusive and binding upon the respondents, the learned single judge has failed to consider and appreciate this undisputed factual aspect, culminating in the erroneous order passed by the learned single judge, which aggrieved by which the appellant is before this court by way of the present appeal. Full stop. As rightly contended by the learned counsel for the appellant, the material on record clearly discloses that the aforesaid order dated so and so passed by the tribunal has attained finality and become conclusive and binding upon the appellant as well as the respondents, and consequently, the respondents were duty bound to consider the representation of the appellants in the light of the aforesaid order passed by the Karnataka Appellate Tribunal, Bangalore. Full stop. It is therefore clear that the impugned order passed by the learned single judge is erroneous and contrary to the material on record, warranting interference by this court in the present appeal. In the result, we pass the following order. Appeal is hereby allowed. Impugned order dated so and so passed by the learned single judge is hereby set aside. Respondents are directed to address the grievances of the appellants and consider and pass appropriate orders / take appropriate decision on the aforesaid representation of the appellants dated 23/9/2020 in accordance with law, bearing in mind the aforesaid order dated so and so passed by the Karnataka Appellate Tribunal, Bangalore, within a period of 3 months from the date of receipt of a copy of this order.
So great.
Rahul is ready. Ready, objections are ready. E-filing has taken place, my lord. So physically, it will be filed tomorrow, my lord. Today, my lord. It may be called tomorrow or day after tomorrow, my lord.
We have carried out the impleadment.
Cost title is filed.
But with the amended cost title.
AGA, appearing for respondent, informs that a statement of objection is ready. He will file the same during course of the day. Next week.
Here for the petitioners.
Last time we had said we will hear this.
It is working now.
It's a committee of 5, and the next meeting is proposed to be held in the first week of April. The proceeding sheet also produced by me along with the status report.
Last time they had said it's a recurring daily problem.
No, Lord, this,
So the matter has to be heard. You hear the matter.
Please, my lord, the only difficulty is the joint committee report, the joint report. They are the two persons who are required to explain. They were absent.
You hear the matter itself.
This is absolutely that playing. This is not the first instance. Your lordship not directed them twice in these proceedings. Done it single judge has done it from October. They are running into 6 months, and they say that the officers did not come. They did some.
Only short question was with respect to acceptance of technical committee report.
Please.
For which, what for the experts and everything and all that is required.
They have submitted their report.
They are part of it.
Probably the London single judge had said that the technical committee report shall be accepted.
They are also part of the committee, my lord. They are also part of the committee of 6. And the expert committee, they failed to appear, my lord. I have filed the emails also, where they had pleaded the difficulty.
If they don't appear, you take a decision. How can we keep on waiting?
In fact, a decision is taken to seek inputs from them, my lord. With
They
regard
can decide about it whether the technical committee report is to be accepted or not.
Hear the matter.
there are certain
This
inputs.
is the only question, that whether the technical committee report is to be accepted or not. Now you are not being able to take a decision on your own, then we will decide it.
Lord,
My request, Your Lordship, is there are 2 issues. One is with regard to the technical report which the government themselves have brought before the Honorable Court. The other issue is not with regard to the withdrawal. Now, I have been requesting, Lord, even before the learned single judge and before Your Lordships at the last occasion, kindly deal with my petition and consider my request not for interim prayer. They have arbitrarily overnight withdrawn without even giving us any reasons. A single line order, I pointed out.
That government order,
Government orders. Not that the scheme be.
that was without any reason.
Absolutely no reason. Arbitrary on the face of it. So therefore, Your Lordship may say that and let the situation which existed prior to the withdrawal continue.
No, they said on the last date probably they said we remember that it was against the central government's direction or something. Therefore, they had withdrawn it.
Please,
This is what.
Please, that is a submission that I
They
made.
say that not now before Your Lordship, but the impute order does not say anything like that. But I also pointed out to Your Lordship.
But Mr. If even if it is against the direction of the central government, then also you will have to pass a fresh order without giving any reason. You have withdrawn. That is all.
In fact, the committee has sat on 11/3, my lord. They have decided to seek certain inputs from the experts, my lord. That is the only reason it has been postponed.
Oh, then you will have to consider their request for interim relief. You are not.
Lord, a genuine reason is also stated. I have placed this material before my lord also with regard to
You take your decision, do whatever has to be done. Once withdrawal is said, automatically you will have to, then probably all their difficulties will come to an end and they'll come and.
one indulgence, my
We
lord.
grant you time, and we will stay there. That order. Because now nothing can be done. It's too much.
Small indulgence, my lord.
Not in 15,767 of 21. It will be 15767.
That is on page 117. This is 3522.
Correct. In this will have to stay.
Page 117 and page 119. That is in the PIF, where the translation copies are there. But the challenge to these orders not is in 15767 of 2021.
We'll have to pass an interim order in the writ paid other paid. WP
15767 of 2021. Serial number.
We had virtually stayed it last time. Last time we had stayed it, but now we'll have to expressly state.
Give the reference of their order, no?
Correct. We'll give the
First
reference.
quote.
Oh.
Except A and B to this petition. Page 41.
A and T or K and L here, is it?
A and B.
Same are K and L here.
Exactly.
And you have asked for stay of A and B.
A and B.
Right. Only one PIL, rest of them are individual matters.
Individual petition.
In this batch of matters in which,
I make one submission. Statement of objections is filed in that petition also, my lord.
right,
Yeah, we have filed statement of
we
objections.
have virtually stayed annexure K and L in the last time. We are only passing an express order of stay now. Because your committee members seem to be.
Not.
One small indulgence, my lord. Next.
No, every day
You take a decision, in the meantime it will remain a state. We had said it without being influenced. Now we will say that it is a state. You take a decision, that is all. It doesn't make a difference in both the orders. Earlier also we had said that you take a decision without being influenced by the withdrawal of the government order. Now we will stay that order. What else can we do? That's right. Already we have passed the order, we are now only clarifying it.
In this batch of matters, in which WP 3522 of 2022 is a public interest litigation, the legality, validity and correctness of the impugned orders dated 15/5/21 and 25/21 issued by the state government are assailed by the respective writ petitioners. Full stop. Heard learned senior counsel for the petitioners and learned AGA for the respondents. Full stop. On 2/3/2022, this court passed the following order. Next para. Pursuant thereto, learned AGA has filed a status report dated 14/3/2022. Inter alia stating that since the committee members are not in station, they are not in a position to attend the meeting scheduled to be held on 11/3/2022, and the next meeting is scheduled to be held during the first week of April 2022, and accordingly adjournment is sought on behalf of the respondents. Next para. Per contra, learned AGA, the learned senior counsel for the petitioner, submits that despite the facts and circumstances of the incident case and the aforesaid order dated 2/3/2022 passed by this court, the respondents are unnecessarily protracting the proceedings on one pretext or the other, despite several directions issued by this court.
What is that order of learned single judge? By that order it was directed. '91. '93.
We'll refer to entire annexure H, sir, all the series of orders. We'll say everything. Full stop. All those orders, right? All those orders.
They should revisit the matter all over again and come with proper solution. '93 पे जो है ना, 93.
Annexure H, the entire thing. Full stop. It is also pointed out that a perusal of the orders in the connected writ petitions by the learned single judge produced as Annexure H to WP 23522 of 2022 will also indicate that the respondents are taking time on one pretext or the other and are dragging on the matter. Full stop.
Hey, specific directions have been issued.
That in WP
page 91, which order you
91,
want to
93.
Show? Which order you want to show?
All right.
12th December, the direction was issued to the state government to revisit the entire issue. Where is that?
Page 90. 90.
Page 90, yes.
This is in reverse, sir. Case status comes, latest orders come first. Yes.
Line to the bottom, above serial number 5. He would submit that the same thing issued without assigning reasons is unsustainable. Learned ADS put on notice that in the event the state is unable to assist the court on the next stage of hearing, officials shall be squarely responsible for any orders that may flow from this court. I number so and so is preferred in petition number so and so for amendment.
Point out.
Right. So also in WP 16153 of 2021, comma,
19.
on 10/12/2021, comma, learned single judge issued the following directions. Extract input. Full stop. A perusal of the aforesaid orders passed by this court will clearly indicate that the, shall we say, sir, that the state government is, now shall we say, the state government is not taking any steps,
Not taking
any decision in the matter.
In the matter, and the impugned order does not show any reason.
Right, full stop. It is also relevant to state a perusal of the impugned orders at annexure K and L in WP 3522 of 22, which is also produced as annexure A and B in WP 15767 of 21, is a non-speaking, cryptic, bald, and laconic order without any application of mind and without assigning valid or cogent reasons. And consequently, the impugned orders dated 15/5/2000, what is that? 15/5/2021 and 25/2021 deserve to be stayed and are prima facie illegal, arbitrary, vitiated, and violative of principles of natural justice, and the same deserve to be stayed pending decision in all the petitions. Full stop. In the result, we pass the following order. Pending disposal of all the petitions, comma, the impugned orders produced as annexure K dated 15/5/21. Doesn't matter. Okay. All right. Pending decision, the impugned orders produced as annexure A dated 15/5/21 in WP 15767 of 21 and annexure B dated 25/21 in annexure in WP 15767 of 21 are stayed till the next date of hearing. Released in second week of April.
The decision taken by the government on the technical order.
They say first week of April, let them file. Released second week of April. Another fresh status report to be filed by the next date of hearing.
With respect to the acceptance of technical
committee report. These two are stayed automatically. All right. It is needless to state that upon the staying of the impugned orders dated 15/5/21 and 25/21, comma, the order dated 5/5/21, which was sought to be withdrawn by way of the impugned orders, will revive and continue to remain in force and be effective henceforth. 5/5/21 and 27/20, right?
The annexures which you have mentioned regarding the order 15/5, take it from the PIL instead of connected with.
Because the English translation.
From the PIL.
Draft,
Those annexures
draft
which have been
Kalpudi,
stayed.
chamber Kalpudi mat.
Right, because what we have said, election number
do it and properly do it.
2nd.
11th April.
Filing of second hearing.
office objections in all the petitions to be complied with by next date of hearing.
Any urgency? This is final hearing, we will have it after.
I will.
Bring the record.
My Lord, I will secure the record so far as revenue records are concerned, my Lord. A spot inspection was done. Spot.
Including the report of the forest settlement officer.
So you give it to him. It will secure it. The learned counsel for the petitioner informs that record would be required. The learned AG appearing for respondent may secure the relevant record. Just give a date after 2 weeks for hearing.
20th April.
Lord, I appear for the respondent in this matter. Lord, this appeal is filed by Lord, a party in person. And IM Lord for production of additional documents are filed. Is filed, Lord. Lord, my objections to that IA is ready. Lord, I will serve the copy on the party, Lord, and Lord, may kindly have this the next week.
Respondent wants times.
You have filed some IA for which they want to file objection.
I mean, if objections are ready, my Lord, we will serve it today, my Lord. I will serve it.
Counsel for respondent informs that statement of objection to the IA has been prepared. He will file the same, giving copy to the party in person within 2 days.
Yes, my Lord.
Give a date. Urgent list.
29 March.
Please, my Lord.
In this matter, I appear for respondents 2 and 3. But there is some urgency in this matter, my Lord, because there is a...
Appearing for respondent number 2, Your Honor.
Essentially, what has happened, my Lord, the apprehension of the petitioners is that the construction of a ramp near a power station will aggravate the pollution, the environmental pollution in the area. Whereas, in fact, we have produced documents and a map to show that it will actually alleviate the problem, not aggravate it. But there is some urgency in this matter.
R2 and R3.
KPCL, Power Corporation.
Is there any restraint order?
There is, madam. There is an interim order dated 18/3/2021. The challenge is to finalization of a tender. The court had granted us permission to complete the tender process but not place the order. Whereas our difficulty is, whereas the price bid has a validity of 180 days and that last date expires on the 20th. And therefore, Malats, the contractors may not stick to the same price. They may try to renegotiate, or Malats, we will have to retender, which is the reason why, Malats, there is some urgency in hearing of this matter today.
Fly ash.
It is fly ash, Malats. And we have taken steps, Malats, to ensure that there is no issue at all. Malats, we have produced the readings of the Karnataka Pollution Control Board, which shows that there is no high levels of pollution in the area.
What steps you have taken? You kindly bring it.
I will. Malats, the challenge.
Whether they are on record.
They are, Malats. We filed our objections, Malats, and we have also filed a map, Malats, from Google Maps, which shows the route and the alignment, which shows that, Malats, the problem is actually being addressed.
Fix it. Give it in.
Could it be, my lord, sometime this week, my lord? The only difficulty
This
is-
week, not possible. Next week. Give a date in the next week. Heard on IA number such and such, filed by respondent number 2 and 3, showing urgency in the matter. Placed on itna, I disposed of.
Next week.
My lord, could I request this, my lord? Could we award the contract subject to the result of the petition, my lord? Because the last date for
We
validity.
will have to hear today. Matter is not before us. It is only for the listing of the matter.
Very
We have fixed the date.
Great.
24.
You have moved the application.
I have moved the application, my lord.
Yes.
Representation, my lord. Annexure G is produced wherein the authority has considered as given a reply. And during the pendency of the petition, my lord, the spot inspection was done. Where the petitioner was also heard, my lord.
What remains? Then?
Does not survive for consideration is my submission, my lord.
Yes. They have decided your representation. Now, if you are aggrieved, go and challenge it.
And also, my lord, they are challenging the, my lord, in respect of the preliminary provisional approval of the layout, my lord.
Decide your decision.
As per annexure D, my lord, we have authority has given an endorsement to the that, my lord, at the final approval, my lord, we consider and pass an appropriate order in respect of mandamus. In respect of, my lord, they have given an application, my lord, to the authority, my lord, to encroach some development lands is concerned, government land. We have only approved the provisional approval, layout approval, my lord. We have said that, my lord, at the final approval, we have considered all contention raised by the petitioner and passed an order, appropriate order. As per the annexure D, my lord. Page 29 and 30, my lord. The English version is 30, my lord. Last portion, my lord. 31, my lord. May I read? All works are in progress.
Just a minute.
They have passed an order of provisional approval. Now they are saying
I think that otherwise also it is personal dispute whether दो लोगों के बीच में जगह है.
correct.
Entertain हो जाता है. Will dispose of.
Moreover, my lord.
Right.
Moreover, my lord.
We won't say anything. We'll only say provisional approval has been granted.
So, whenever you pass the final approval, you will consider
Their representation.
Same endorsement has been passed, my lord. We have passed.
In this petition, petitioner is sought for the following reliefs.
Sorry, petition doesn't deserve even for one day to be kept.
Heard, Gatala, heard petitioner, respondent. Full stop.
Party in person and respondent.
No, I think she's a lawyer. You're a party in person, madam.
I thought that you are party in person. Your band is not seen.
Correct.
All right.
Right. A perusal of the relief sought for by the petitioner will indicate that it is a grievance of the petitioner that the representation at annexures D, E, and F dated 1/10/20, 6/11/20, and 22/12/20 have not been considered by the concerned respondent. Number one, full stop. However, annexure G dated 24/12/2020 will indicate that a provisional order of approval was issued by the respondent number 2, planning authority, who has full stop. It is submitted on behalf of respondent number 2 that subsequent to 24/12/2020, when the provisional approval order was issued, the respondent number 2 has so far not issued any final approval order as on today. Full stop. Full stop. In view of the aforesaid submission made on behalf of respondent number 2, we deem it just and appropriate to dispose of this petition, directing the respondent number 2 to pass a final order of approval in accordance with law after considering the petitioner's representations, pending representations,
last representation,
including the representation dated 22/12/2020 submitted by the petitioner. Full stop. Subject to directions, petition stands disposed of.
IA also.
All pending IAs stand disposed of.
25.
Your Lordships have passed an order on 17/2/2022, my Lords, directing the government to cancel the tender and also to consider criminal action. Firstly, my Lords, my apologies to your Lordships that this party did not appear before the court earlier. Explanation provided in the application is, my Lords, that in transit from the liaison office to the site office, the papers were lost, but my Lords, I don't think that would impress your Lordships. But one crucial development is, my Lords, that on 25/1/2021, we were given a further extension, my Lords, till 31/12/2021. Unfortunately, my Lords, neither the petitioner nor the corporation.
What is the IA?
IA is, my Lords, to recall your Lordship's order, because now, my Lords,
We will hear the matter. Let the other side be present.
they are proposing to take some precipitate action now by.
Heard on IA number 1 of 2022. List on. Give a date. Note the appearance. Note the
31/3.
Lords, one request in the meanwhile. Let precipitate action, at least on the criminal side, not be
It is
taken.
only an application. We will consider it on the next day.
This we have done, and now they are saying they have already cancelled.
But surprisingly,
No, but till then, if they on the criminal side, if they arrest him or
Give next week.
next week, your Lordships may then kindly keep it first.
21st.
Please. Lords, if they have terminated, a copy may be furnished to us. We have not even received the termination.
Take her for a cup of coffee.
I'll do that right away. Lords, I only wish they had brought to your Lordship's notice an extension order.
We'll consider next.
Clearly, Lord. Second extension order, my Lords, has not been mentioned to your Lordships.
No, but we have not.
No.
Our order doesn't speak about any extension order. No, we have proceeded on the basis that there is no extension, and therefore we have you are entitled to terminate.
We'll see on the next date.
Please, 21st.
Grateful. Number 26. Vipaksha PL.
As a
What is your IA?
Seeking leave of the court to file the appeal, present appeal.
That you can file along with the appeal. It is not necessary. At that time you had not filed it. IA was not filed.
Imprisonment application. Imprisonment application rejected by learned single judge who disposed of. Say, now they have again.
Passover matter.
Lord, I am for petition, my lord.
1 and 2, my lord.
We'll dismiss it.
No, my lord, I request, my lord, tomorrow, my lord, because I given NOC, my lord, on record counsel, my lord, if I did an NOC.
Oh, you are not appearing.
No, my lord, I have a petition, my lord. I given NOC to the
You
one
have given
Mr.
NOC now, you have no right to appear.
No, my lord, actually today is inquest, but tomorrow, my lord, I have to tomorrow, my lord. I request, my lord, court, my lord, tomorrow, my lord.
No, sorry. You please sit down. Don't appear in this matter. You have given NOC.
No, normal, because
List is being revised. So and so. Advocate. Take the name Vidyanand Arai. Informs that earlier he was appearing for petitioner, but now he has given no objection certificate to the petitioner, and as such, he is not appearing for the petitioner in the matter.
he is not well today, my lord.
The petition has been filed seeking following relief. You represent respondent.
Happy for R1 and R2, my lord.
So and so is present for R1 and R1 and R2.
Please, my lord.
I represent RC.
Huh?
Respondent number 6.
AGAP as for respondent number 6. The writ petition is dismissed in default as well as for want of prosecution into model finished and discharged.